Good morning and welcome to this Landmark Chambers webinar. I can see that people are joining all the time, but we're going to get off to a start. My name is Neil Cameron QC, and I'm going to chair the session today. And I'm joined by my colleagues Sasha White QC, Stephen Morgan and Matthew Dale Harris. Jenny Wigley QC is also going to give a talk, but that is going to be a pre-recorded talk as she's not able to join us today. So to begin with, a few housekeeping points to get those out of the way. Your microphones are automatically muted, so you don't need to adjust your local settings. We very much welcome questions throughout the session, and the way to do that is by using the Q&A section. So if you submit your questions in writing, we will then deal with as many as we can after the talks, when we're going to have a panel discussion. The webinar will be recorded and you will receive a link to the presentation and the recording shortly after the seminar concludes. If at any time your connection is lost during the webinar, what we invite you to do is to rejoin the meeting by clicking on the original link. Now, this is part 2 of this year's Landmark webinar series on High Court challenges. Many of you will be familiar with our annual seminar, in which we provide a review of important cases over the last year or so. In today's session, we're going to cover challenges relating to interpretation of the National Planning Policy Framework, heritage cases, and local plan challenges. So lots of material to get through in a 1.5 hour session. Perhaps the general theme to which I draw attention is that the courts appear, particularly the higher courts, to resist the tendency of claimants to put forward overcomplicated approaches to the interpretation of policies and indeed statutes. And that, those issues we will discuss today. So here I will now introduce our presenters, those giving the talks. We have Jenny Wigley, who specialises in planning, environmental law and rating. She is a skilled advocate at inquiries and in particular in the High Court, and she was selected one of the Planners Women of Influence in 2021. We have Sasha White QC. He's well known to most of you as one of the creators of Have We Got Planning News for You. He's head of the planning group at Landmark, and he's practiced in this area of law since 1991. And he appears at around 20 appeals a year for developers, local planning authorities, and third parties. We then have Matthew Dale Harris. Matthew has a wide planning and environmental law practice. He's a member of the Attorney General's C panel of counsel and regularly acts for both government and developer clients. Recent highlights include successful promotion of a 120 dwelling scheme in Braintree and acting for Bolton Council in support of the Hulton Park Ryder Cup golf course proposal on a call-in. And then Stephen Morgan. Stephen graduated with a master's degree in environmental planning, and as a barrister, he's always specialised in planning and related matters. He's got a very wide range of experience, particularly in relation to development plans, which he's going to talk about today. He's been involved in local plans throughout his career and recently promoted a new settlement of up to 10,000 houses through a local plan. He also has a special interest in neighbourhood planning, which we will hear about when he talks. I'm now going to hand over to Jenny.
Thanks, Neil. Well, good morning, everyone. I'm going to be speaking about the latest NPPF cases, and I think also in my title was housing and the tilted balance. And that's going to take up quite a good part of my talk because there has been a proliferation really of cases dealing with that in the last year or so. So the topics I'm going to be covering: housing and the tilted balance, as I just said, and then a couple of cases on the greenbelt, one on retail and one on gypsies and travellers. So starting with housing and the tilted balance, sorry, I just jumped a slide there. I'm going to be focusing on, first of all, the tilted balance under paragraph 11, obviously, and 11D specifically, which deals with both the triggers for the tilted balance, the disapplication, which can occur where there are specific NPPF policies, and then how the tilted balance applies itself. So we'll start with the trigger, and there's a Court of Appeal decision, Paul Newman New Homes Limited, which deals with the first possible trigger under 11D, which is that there are no relevant development plan policies. This case concerned a proposal for housing development, and the inspector found that it was contrary to one local plan policy, which was quite generic, dealing with design and rural character and appearance. Because that was relevant to the proposed development, he held that there were relevant development plan policies, or at least one, meaning that the first trigger of the tilted balance could not be met, and the tilted balance therefore did not apply. The developer challenged that decision on the basis that the policy that the inspector had identified was too generic to be a relevant policy in the context of 11D and to disapply the tilted balance. The developer argued that to be that type of policy, it had to be more specific to the development in question. So say relating to affordable housing or a specific location. Because the policy was more generic, the developer said that that didn't have the effect that the inspector had found it to have. The High Court disagreed, as did the Court of Appeal. They held that relevant in 11D means simply nothing more than having some real role in the determination. There's no requirement for the policy to be determinative of the application or appeal for it to disapply the tilted balance in that way. And as is often the case with these types of decisions, the courts reiterated the issue of how important a policy is to determination is a question of planning judgment for the decision maker and not an issue for the court. Therefore, the first trigger, no relevant development plan policies, will not be met if there is even just one policy that plays some real role in the determination of the application, meaning that it's really quite a low threshold for there to be a relevant development plan policy, which means that in practice it will be very difficult, and it has been very difficult, to use that trigger. In reality, if there is any development plan in place, it's quite likely that that trigger won't apply. So I move on now then to the second possible trigger for the tilted balance, the one that we're perhaps more familiar with its application, and that's the out of date, where the most important policies for determining the application are out of date. If that's the case, then that's obviously another basis on which the tilted balance will apply. This case, Peel Investments, another decision of the Court of Appeal, concerned a site which was in a green wedge protected by development plan policy. And at the appeal, the developer had argued that that green wedge policy was out of date because it was in a time expired development plan. The Secretary of State, agreeing with the inspector, disagreed and said that the green wedge policy was not out of date and accorded it full weight. So the question for the court was whether the fact that the policy was in a time expired plan meant that it was automatically out of date as a matter of law. And the Court of Appeal found that that was not the case. There's nothing in paragraph 11D to suggest that the expiry of the period of the plan automatically renders the policies in the plan out of date. Again, as often the case, this is all a matter of planning judgment. In this particular case, the green wedge policy addressed environmental protection, which the court held clearly had a life beyond the expiry of the plan, and the Secretary of State's approach was therefore entirely lawful. But of course, it's still open on that basis for a decision maker to find that a policy is out of date because it's in this time expired plan as a matter of planning judgment. So if there are particular reasons in a particular case for considering that the expiry of the plan renders the policies in it or a particular policy in it out of date, then an inspector can take that route. But the point is that it's not automatic, and as a matter of law, a policy will not be out of date just because it's in a time expired plan. A couple of other cases on out of date. Again, another case in the Court of Appeal, Oxton Farm. This is a useful example of where a local planning authority was held to be justified in determining that housing policies in an extant core strategy were out of date, and so the tilted balance was triggered, and that was the case even though there was a 5-year housing land supply. Similar, or slightly different but similar example in the High Court, the Ewens case against Mid Suffolk District Council. That was also a case where the LPA was held to be justified in determining policies were out of date and in applying the tilted balance, even though there was a 5-year housing land supply. In both those cases, there was a particular reason for finding the policies to be out of date, relating to more recent housing need and supply information in emerging policy documents. The Ewens case is also interesting because it concerned the weight to accord to emerging plans and the application of paragraph 48 in the NPPF, which sets out those 3 factors to consider when looking at weight to accord to emerging plans. And they are, of course, the progress of the emerging plan, the extent to which there are unresolved objections to it, and the extent to which it's consistent with the NPPF. Those 3 factors must be considered when looking at emerging plans, but they're not necessarily determinative. In this particular case, there were 2 emerging plans, an emerging local plan and an emerging neighbourhood plan, and the local planning authority accorded more weight to the local plan that was emerging on the basis that it was based on a more recent assessment of housing needs. The court held that that was a relevant factor, and so long as the paragraph 48 factors were also taken into account, there was no reason why the assessment of housing needs could not determine which one was more weighty, which emerging plan was more weighty. So the paragraph 48 factors were relevant but not completely prescriptive. So I now move on to Monk Hill, and this concerned the other aspect of paragraph 11, which is where the tilted balance will be disengaged where there are policies in this framework that protect areas or assets of particular importance, and those policies provide a clear reason for refusing the development proposed, and that's paragraph 11D1. In Monk Hill, again, another housing development, this time in an area of outstanding natural beauty. There was no 5-year housing land supply, so the most important policies were deemed out of date, and the tilted balance would apply unless D1 applied, which was that the policy in the framework provided a clear reason for refusal. The inspector found that in this case, the harm to the AONB was a clear reason for refusing permission because of the application of paragraph 172, now 176 of the NPPF, which of course states that great weight should be given to conserving and enhancing landscape and scenic beauty in the AONB. And that harm to the AONB in this case was considered a clear reason for refusing the development and for disapplying the tilted balance. The developer argued that that was the wrong approach on the basis that paragraph 172 of the NPPF was not that type of policy to apply to provide a clear reason for refusal, because it didn't have an internal test which if not met, provided that the proposal should be refused. That argument was rejected both by the High Court and the Court of Appeal, and the inspector's application of the NPPF policies was found to be lawful. The court held that paragraph 172 clearly envisaged that if the great weight to be accorded to the AONB was not outweighed by benefits, then the development should be refused. And that type of policy could fall within 11D1 and could provide a clear reason for refusal and for disapplying the tilted balance. Monk Hill's also a useful case for its High Court judgment of Mr. Justice Holgate, which provides a 15-point route map to applying paragraph 11. And I commend that to you if you haven't already seen it, and I give you the reference at the bottom of the slide. Now then to the tilted balance itself and how that's applied, and that's in 11D2, which of course we're all very familiar with, says that planning permission should be granted unless the adverse impact of doing so would significantly and demonstrably outweigh the benefits when assessed against the policies in this framework taken as a whole. And in this particular case, the issue was whether the inspectors could take into account policies in the development plan when applying the tilted balance. The claimant developers argued that in this framework taken as a whole, that wording in D2 meant that it was only policies in the framework that should be taken into account at the tilted balance stage, and not policies in the development plan. So that issue was before the court, as was the issue of how you apply the tilted balance with section 38.6 duty, and whether they should be separate tests and sequential steps in the decision making. The High Court and the Court of Appeal dismissed the challenge. On the first issue, the court found there was nothing in the tilted balance which required development plan policies to be disregarded. Slightly awkward decision, given that that limb of paragraph 11D does specifically refer to policies in the framework and not development plan policies. But nevertheless, the court applied a more sort of broad brush approach and considered that development plan policies could also be taken into account when applying the tilted balance. And in terms of any sequential or separate tests, the court stepped back and considered that this was a matter for the decision maker as to how to go about the decision making process. So long as both were taken into account, both the tilted balance and section 38.6, that could all be done in one all-encompassing stage. But the decision maker had to be vigilant to keep in mind the statutory primacy of the development plan, and of course the statutory requirement to also have regard to other material considerations, including the NPPF and the tilted balance. So a fairly laissez-faire approach to how the statutory decision making is undertaken, as long as everything's taken into account. Lastly, on housing and the tilted balance, this is more on the housing side of things, which is how to determine the 5-year housing land supply. The LPA in this case, it's a very recent case actually in the High Court, challenged the inspector's decision for failing to take into account a previous oversupply when calculating the 5-year housing land supply. So the planning authority had exceeded the housing requirement in earlier years of the local plan, but going forward had a deficit. And the issue was whether that oversupply could be set against the deficit going forward. The LPA was arguing that the inspector was wrong to ignore that earlier oversupply, but that challenge was rejected. The court held that the NPPF was silent on whether or not an earlier oversupply should be taken into account. And because of that silence, it was a matter for planning judgment for the inspector. In this particular case, the inspector had good reasons for deciding not to factor in the oversupply, given her concerns over the future supply trajectory. However, obviously, because this is a matter of planning judgment, there would be other cases where it would presumably be appropriate to take into account the previous oversupply. And one example that springs to mind is that otherwise an LPA could potentially be disincentivized for being proactive in encouraging supply to come forward quicker than projected, because otherwise it might be penalised later if there's oversupply earlier on and undersupply later. So that might be a factor going forward in the planning judgment. But as I say, it's a matter for planning judgment rather than a matter of law as to whether that oversupply should be taken into account. Just then on to a few other issues, moving away from housing and the tilted balance. A few cases on the greenbelt. Sefton is a case about the very familiar paragraph in the NPPF, now 148, was 144, which is the one about substantial weight being accorded to harm to the greenbelt, including the harm by reason of inappropriateness and any other harm. The claimant in this case said that, or argued that, substantial harm should have been accorded by the inspector to each aspect of the harm to the greenbelt. So not just the harm by reason of inappropriateness, but also the harm to openness and the harm caused by the encroachment into the countryside. And the claimant criticised the inspector's decision, which had referred to the harm to the openness and the encroachment in the countryside as being other additional aspects of harm, but not specifically according those substantial weight. The court rejected the challenge on the basis that it was over forensic and that the decision maker had applied a single exercise of planning judgment to assess whether there were very special circumstances to justify the grant of permission, and looked at in the round had applied substantial weight to the harm to the greenbelt. It was not necessary to apply substantial harm to each element and to add those harms up in a sort of mathematical or mechanical exercise. Another case on applying greenbelt policy is the Co-op group. This follows on from the Supreme Court case in the old Samuel Smith Brewery, and how openness is interpreted and applied. In this case, the planning officer recommending approval to the committee had characterised openness as meaning the absence of visible development. And the claimant argued that that meant that the factors that were being taken into account in assessing openness were unduly limited and had been restricted by the way the officer had characterised openness. The court very much took a step back and said that the application of openness and how it applied to a particular case was very much a matter of planning judgment, not a matter of law. There were no specific factors that had to be taken into account as a matter of law. And so long as the application was done rationally, as it had been done here, the court would not interfere. So again, a court according planning judgment and the planning decision maker a wide ambit in decision making in relation to openness, as the Supreme Court did in Samuel Smith. Finally, on greenbelt, not specifically a greenbelt case, more a case relating to local green space policy. Localhort Investments concerned a policy in a neighbourhood plan designating local green space and applying more restrictive tests to development in that local green space than would be in national greenbelt policy. The policy required that any development in the local green space had to enhance the original use of the local green space and enhance the reasons for its designation. And that would exclude, for example, development that would otherwise be appropriate in the greenbelt, or development that might be justified by very special circumstances. Now, because paragraph 103 in the NPPF requires that local green space development control policy should be consistent with greenbelt policy, there needed to be specific justification for having the local green space policy more restrictive than the greenbelt policy. Because there was no specific justification for that more restrictive approach, the court held that the local green space policy was unlawful and should be quashed. Then just a couple of cases on other matters. First on retail, the case of Asda Stores against Leeds, another Court of Appeal case of this year, that concerned the NPPF policy in paragraph 90, which is now in the 2021 version is paragraph 91. And that provides that out of town retail developments should be refused if they were likely to have significant adverse impact on town centre vitality and viability. And the argument here was that that created a presumption against such development if it was found to have such significant adverse impacts. the court held that the paragraph 90 did not create such a presumption. It simply created a material consideration in the sense that if a proposed development would have a significant adverse impact on town centre vitality and viability, that would be a material consideration against it. But that material consideration could be outweighed by other policy considerations, including other policies in the NPPF. And as such, paragraph 90 did not have trumping status over other policies in the NPPF, and the challenge was rejected. And then finally, I just wanted to turn to a case on gypsies and travellers, not specifically the NPPF, but the Planning Policy for Traveller Sites 2015, which since 2015 has included a definition that now excludes those who have ceased to travel and have settled permanently. It was argued that that definition unlawfully discriminated against elderly and disabled gypsies, contrary to the European Convention on Human Rights and the Equality Act. That challenge was rejected. The court held that the definition only applied in respect of land use needs and policy and had to be read with the NPPF. So whilst it did discriminate against elderly and disabled gypsies in that sense, in providing for their land use needs, that was held to be a legitimate aim of meeting such needs on those with a current nomadic lifestyle. And for that reason, that element of discrimination was held to be objectively justified. And part of the reasoning was that the discrimination was not as bad as it might otherwise appear, because under the NPPF, the decision maker on an individual application would still need to consider the cultural needs and the other personal circumstances of permanently settled gypsies and travellers. And so the needs of those elderly and disabled gypsies would be taken into account in the decision-making stage in that way. So that's my quick run through of cases on the NPPF. And I'll now hand you over to the next speakers, who I think are Matthew and Sasha, dealing with heritage. Thank you.
Thank you very much. Good morning, everybody. Sasha and I have divided this subject into two talks. So I'm going to be focusing on the Court of Appeal's decision in City and Country Bramms Hill, which is an important case on the assessment of heritage impacts, and also deals with the interpretation of isolated homes. And then Sasha's going to be looking at the wider heritage cases, including the Stonehenge decision on alternatives, as well as the Juden decision in relation to ancient trees. So City and Country versus Bramms Hill in the Secretary of State, it arose out of a complicated development dispute involving the redevelopment of a Grade 1 Jacobean mansion, which you see on the slide, which is bordered, it includes within its grounds a Grade 1 registered park, and where the developer had sought to convert the house into, I think, 21 apartments, construct 235 houses in replacement for some existing buildings, and also seek regularization of the use of 51 odd units as independent dwelling houses. So there were 33 appeals before the inspector, some of them relating to refusal of planning permission, others relating to enforcement notices. Now, the two main issues, and I think to some extent both at the inquiry and then finally by the time it got to the Court of Appeal, were the meaning of isolated homes in the countryside in what's now paragraph 80 of the framework, and also the approach to the assessment of less than substantial and more than substantial harm, as we now see contained in framework policies 201 to 202. I thought it'd be useful to begin this discussion of the Court of Appeal's findings by setting out some of the background in terms of the key case law on the interpretation of planning policy. I know this will be familiar to most of you, but the story kind of begins with the Tesco and Dundee decision back in 2012, which held that the interpretation of planning policy is a matter of law and thereby significantly expanded the scope for challenge to planning decisions. However, since at least the Hopkins Holmes decisions back in 2017, the higher courts have consistently sought to qualify the scope for the legalisation of planning policy decisions, planning policy interpretation, to prevent over-legalistic attacks. And the distinction emphasised by Lord Carnwath in the Hopkins Holmes decisions was between questions of interpretation which are logically prior to the exercise of planning judgment, and then in Tesco and Dundee, that was questions in relation to the application of the workings of the sequential test contained in the development plan, and other policies which may be expressed in much broader terms and may not require nor lend themselves to the same level of legal analysis. That's Lord Carnwath's description in Hopkins Holmes. He set that out in Hopkins Holmes in the context of the tilted balance, and then in the Samuel Smith decision in 2020, applied that to greenbelt openness. So in Bramshill, in relation to isolated homes, the inspector had concluded that the proposals would create isolated homes, and that was part of her wider conclusion that the proposed housing was unsustainable development. The claimant's argument against that in both the High Court and the Court of Appeal was that that reasoning was flawed because it didn't engage with the decision of the Court of Appeal in Dartford, which was said by the claimant to establish that dwellings within the curtilage of an existing structure won't be isolated. So that was the first flaw, and she'd also failed to consider, said the claimant, whether the dwellings on site themselves formed a settlement, applying the approach in Braintree, another Court of Appeal decision. Finally, it said that she failed to consider how the quantum of housing sought under one of the appeals could rationally be said to result in isolated homes. This, I think, was a submission that really tied into the second ground of challenge. Sir Keith Lindblom, President of the Tribunal, gave the leading judgment of the court. He emphasised, in strong terms following Hopkins Holmes and Samuel Smith, that the concept of isolated homes was one of policy, not law, and does not lend itself to rigorous judicial analysis. And interestingly, I think probably for the broader approach to interpretation of the framework, he said, as with many other broadly framed policies in the framework, its application will depend on the facts of the case, and decision makers will have to exercise their planning judgments in a wide variety of circumstances. Having set that out, he then confirmed the essential interpretation of this policy in the framework as set out in Braintree, the essential conclusion being that where a decision maker is determining whether a particular proposal is for isolated homes, the decision maker must consider whether the development would be physically isolated in the sense of being isolated from a settlement. And what is a settlement and whether it would be isolated from that settlement are both matters of planning judgment. He also, I think this is a good reminder, certainly for the lawyers amongst us who work frequently in contexts where these cases are being applied, but also for the broader world of planners applying these cases, he stressed the distinction between what was the ratio in Braintree, the particular finding, the particular logic that led to the decision, and the obit comments that had been made by the judge in that case and by Lord Justice Lewison in Dartford, a case which had been about the meaning of previously developed land, not about the meaning of isolated homes at all. And he stressed that the decision makers and advocates and planning professionals should keep in mind those the different functions of those particular kind of comments and not seek to over apply obiter comments. That being said, he couldn't resist a few obiter comments of his own as to the reason why remoteness from a settlement was key to understanding isolated homes, which he said was the approach most consistent with the government's evident intention in producing the policy. On the facts of the case, the inspector had referred to Braintree and her reasoning was unimpeachable. In relation to heritage, the appellant argued that the inspector had failed to comply with the principle in Palmer, Now, the Palmer decision, I'm sure will have come across the desks of many of you. It was a case where Lord Justice Lewison again considered a challenge to a local authority decision where the officer had advised that there'd be no overall adverse effect on the setting of listed building arising from noise and smell of poultry sheds if proposed mitigation measures were put in place. Essentially on the basis, as explained by counsel for the council, that there was a balance being struck there between positive impacts, positive benefits to the setting of the listed buildings from the mitigation against a residual adverse effect from the noise and smell of the poultry sheds. And Lord Justice Lewison rejected the claim that that was an unlawful approach and said, I'd accept that where the proposed development would affect a listed building or its setting in different ways, some positive and some negative, the decision maker may legitimately conclude that although each of the effects has an impact, taken together there's no overall adverse effect on the listed building or its setting. And that was relied upon in many, has continued to be relied upon in many planning decisions as establishing that particularly under paragraph what was 196 and is now 201, I think, of the framework, that you could have an internal balancing exercise to your assessment of heritage harm, which can therefore conclude that there is no harm at all overall. In Bramshill, the appellant at the inquiry argued that the Palmer internal balancing approach was correct, but the inspector declined to apply it because she said that firstly that Palmer didn't, while it reinforced that a balancing exercise needs to be carried out, it does not direct the decision maker to only one method by which that should be done. And she was faced with a situation where the variety of appeals, some of which were said to be net beneficial, some were said to be net harmful, made it difficult to match the harms of each individual proposal against its individual benefits, which would complicate an internal balancing exercise on each appeal. So Keith Lindblom rejected the appellant's challenge and rejected the argument that either section 66 of the Listed Building Act, which is the statutory duty in relation to listed buildings, or the framework stipulated any particular approach to the balancing of heritage harm against likely benefits. He emphasised that the concept in the framework of 199, that great weight be given to the conservation of a designated asset, doesn't predetermine the amount of weight to be given to the conservation of the heritage asset. And as a result, he said that there was no real Palmer principle as suggested. It was open to decision makers to take a variety of different approaches to assessing heritage harm consistent with the framework and the statutory duty. He also went on to consider the concepts of substantial and less than substantial harm more generally, and emphasise that what amounts to substantial harm will always depend on circumstances and is a matter of fact and planning judgment. Again, confirming that the framework doesn't direct the decision maker to adopt any specific approach to identify harm or gauging its extent. He approved them in the context of the case, he approved the methodical approach to the inspector, which is ensure that both harms and benefits were fully appreciated. The latter comment there is, I think, of wider significance, particularly in relation to another case which is widely relied upon in the context of the assessment of heritage harm, which was the decision in Bedford, which is relied upon often by developers seeking to show that the standard of substantial harm is a very high one, and the language from Bedford being it's something approaching a situation where the significance of the asset is more or less totally is vitiated or largely drained away. That particular case, and the applicability of that particular case, was challenged in a case called Western Homes, following the dismissal by the Secretary of State of a called-in application in relation to a large tower, a large residential development in Norwich. the main ground of claim alleged a failure by the Secretary of State to apply a Bedford consistent approach to the calibration of heritage harm. The argument basically being that because substantial harm was such a high threshold, the inspector, the Secretary of State, was mistaken to describe the level of harm, which came way below the qualitative description set out in Bedford, as being towards the top end of less than substantial harm. Mr. Justice Holgate granted permission for the claim and noted that the substantive hearing will provide an opportunity for the court to consider the ratio of the decision in Bedford and the extent to which it remains good law in the light of current policy, and more particularly Brett Hopkins and Samuel Smith. Now, the claim was then withdrawn following the decision of the Court of Appeal in Bramms Hill, but I think we can sort of see from that that there is good grounds for doubt as to whether the more prescriptive approaches that are being put forward on the basis of cases like Bedford are correct in law. So that brings me to the end of my slides, and I'll now hand over to Sasha, who's going to talk you through a range of other cases, including the alternatives case.
Good morning, everyone. I just want to say a couple of matters of introduction. As most of you can now see, it is the lovely underpass that would go under Stonehenge. Now, the main takeaway I want to say in relation to my talk, obviously Matt has done an excellent summary. I mean, as you can tell from what Matt and I have been saying and will say, is that heritage cannot be underestimated. It's one now the most fertile battlegrounds that exist in planning, and the interpretation particularly of the NPPF guidance and sections 66 and 72 is becoming ever more important. And as we'll see in a minute, this is particularly true in relation to High Court challenges where claimants are challenging the grant of consent and the dealing with the heritage sections and the conservation officers, etc. So let me deal first of all with alternatives, and most of you will know the need to consider alternatives has always been a thorny issue, and for many years Trust House 40 decision from the 70s established the kind of context to which alternatives could be considered. Let me just see if I can now change the screen. Yes, and obviously most of you will have known about the Stonehenge proposal, the development consent order for construction of a new route for the A303. Indeed, I drove down it last Monday on my way to Somerset, and what was proposed was a new dual carriageway and with a 3.3 kilometre tunnel. Now, the third parties who obviously sought to challenge that proposal argued that the alternative tunnel option should have been considered at greater depth. And effectively what had happened in that case is the applicant considered alternatives to a degree, but in an options appraisal, which the examining authority addressed, but neither the examining authority or the Secretary of State went on to express their own conclusions about the possible alternatives. Now, the panel, the examining authority and the panel found, and of course most of you will be aware of the relevant section of the NPPF, and at 189 it now says that the highest significance are, in terms of heritage assets, World Heritage Sites, which are internationally recognised to be of outstanding universal value. And of course you can see there that in that case, the panel found that the road would cause substantial harm to the World Heritage Sites. So you have a situation here where you've got substantial harm to a WHS and national guidance saying in 189 that the highest significance should go to the World Heritage Sites. So there's a kind of perfect storm in a sense for the promoters of that scheme. And Mr. Justice Holgate said when considering the challenge by the claimants that the designation of the site as a World Heritage Site and the extent of identified heritage harm that was accepted there did put the case into the exceptional category of cases per the decision in Trust House 40, where an assessment of relevant alternatives is required. And just to summarise, of course, what effectively Trust House 40 said is if you do have material harm, and there are effectively five criteria, but to summarise, if there is material harm and there be alternatives, then it is necessary for the tribunal effectively to consider the alternatives. Now, what the starting point here, of course, is neither the examining authority or the Secretary of State thought that the proposal would be net beneficial in heritage terms. There was acceptance of harm, obviously, to a World Heritage Site. So that is pretty important. Now, in terms of consideration of alternatives, and again, it just reinforces the Trust House 40 dicta that effectively you do need to look at alternatives with that combination of factors. I think I wanted to also bring to your attention some other matters on heritage, and these largely reflect consideration of heritage matters at the local authority level, not at appeals, but by local authority members and committees. And the takeaway point is that in planning officer's report, there needs to be particular care when considering the representations from both internal and external consultees to an application, as well as the statutory duties, whether they be section 66 and 72, and the NPPF provisions in the light of the decision of Barnwell Manor, which of course was to give significant weight to any heritage harm. So the first appeal I want to deal with is a decision of Mrs. Justice Lang in May of 2021, in which I appeared for the City of London Corporation, who were promoting sheltered housing. So quite an they weren't promoting it as LPA, but in Lewisham they own land. It's one of those peculiarities that the City of London do own quite significant pieces of land, including Hampstead Heath throughout London, and this was a site in Lewisham. And what the City of London Corporation wanted to do was redevelop a site of sheltered housing, and the matter was considered by the committee. The Lewisham Committee granted consent, but it was challenged by a local resident, Kinsey, who sought to say that the council had reached an unlawful decision. And effectively, Mrs. Justice Lang endorsed that, and she found 4 errors in law. The first of all was, again, remember my concern about section 72 and section 66, that members were not properly advised to give those statutory powers considerable weight. Secondly, the officer's report omitted and changed several elements of the conservation officer's advice, which was withheld from the public. This is quite interesting because what Lewisham argued, well, effectively a response from a conservation officer was an internal consultation, not an external. It was an internal one and was summarised in the planning report. And its main function was to effectively inform the planning officer. The court found, however, that needed to be before members, and also it needed to reflect what was actually said in the consultation response rather than be paraphrased or amended by the planning officer. And Mrs. Justice Lang also found that it was important that, in accordance with law, that the conservation officer's advice should have been made public, and it is necessary to look at the law relating to background papers and the Local Government Act. There was also a reference to the statement there was effectively statement of community involvement about legitimate expectation that the council would further consult the design review panel post the application being submitted. They had been consulted prior to the application being submitted, but effectively there was an expectation that the council would subsequently consult. Then I want to deal with another case of heritage in Liverpool, which was again a challenge to the grant of consent by Liverpool Open and Green Spaces. And this went to the Court of Appeal, where the first instance conclusion of Code J that the council's application of section 66 was unlawful, because firstly, in referring to the section 66 duty, the council hadn't given an adequate reference to the great weight to the conservation of heritage assets. And secondly, again, no reference to a consultation response from the council's conservation team, which was a strong objection to the grant of consent in the planning officer's report. and that Mr. Justice Kerr at first instance found those 2 flaws were unlawful and justified quashing the grant of consent. And Lord Justice Lindblom, effectively looking at this from the Court of Appeal's perspective, took the view that the Officers Committee report left substantial doubt as to whether the Section 66(1) duty was discharged. Then another case, again, challenge to a decision by Guildford Borough Council. Mrs. Justice Lang earlier this year applied the Liverpool Open Spaces judgment to quash a residential permission near listed buildings. The officer had referred to the introductory powers on heritage in the NPPF, but had not explained how Section 66(1) was to be applied, had not referred to or demonstrably applied the decision-making policies in the NPPF 199 to 201, and the officer's consideration of the potential impacts did not reflect the NPPF guidance. And Mrs. Justice Lang, in quashing that decision, suggested that the application of the more due principles, that if you follow the NPPF in essence, that's sufficient to discharge Section 66, does require that the NPPF is properly worked through for members. So just before I move on, just to summarise on the heritage, I think if those of you involved in drafting and writing planning officers' reports, I think it is pretty obvious that in order to be as safe as possible, you need to set out the statutory duties and terms. You then need to effectively refer to the stages and the steps in the NPPF, and then you need to apply the dicta that Matt has just let out, discussed in Bramms in relation to the balance between the harms and the benefits. So can I just finish with a slightly subsidiary point, or arguably not subsidiary, but disparate, and that is ancient trees. And those of you that follow such matters will note that 180C of the NPPF requires effectively that the loss or deterioration of irreplaceable habitat should be refused unless there are wholly exceptional reasons and a suitable compensation strategy exists. And effectively, footnote 63 relates to infrastructure projects where the public benefit would clearly outweigh the loss or deterioration of habitat. Now, of course, the question is, do you need wholly exceptional reasons and or a suitable compensation strategy, and how those are effectively considered? In Juden and the Tower Hamlets London Borough Council, again another case this year, what was the High Court quashed a decision which related to the redevelopment of the London Chest Hospital, because as we can see from the photo, there was a very nice veteran mulberry tree there. The council concluded that the tree was more likely than not to survive if planning permission was granted, but there was a risk it would not. And the officers had drafted the officers' report on the basis that 180 did not apply. But late amendments to the officers' report identified it as a material consideration and advised that wholly exceptional circumstances existed to justify its potential loss. However, that advice considered as one the suitability of the compensation strategy with the question of wholly exceptional circumstances. Now, the court held that the wholly exceptional circumstance requirement and suitable compensation strategy are cumulative. They must be considered one after the other. And it isn't appropriate to consider whether a suitable compensatory strategy can be achieved as part of an assessment of whether wholly exceptional circumstances exist. In essence, just because you might have a suitable compensation strategy, that would not be a factor that would lead to a wholly exceptional circumstances conclusion. Effectively, they need to be considered separately. It was also noted by the courts that it would have been open to the officers to advise this wasn't a Para 180C case, but the advice should have been and could have been couched in terms of risk and other important factors. Just to note in relation to ancient woodland, that there was very recently on the 20th of October, Undersecretary Defra stated that there was a commitment to review the NPPF to ensure that the ancient woodland inventory is being correctly implemented, and if necessary to amend the NPPG guidance. Most of you will have been involved in ancient or veteran woodland cases. I certainly have. and the government gave an undertaking to consult on strengthening the protection of NPPF wording to better ensure the strongest protection of ancient woodland, whilst recognising the complex delivery challenges for major infrastructure. And it might require the LPAs to consult with the Secretary of State on applications affecting ancient woodland. So that I will now hand over to Stephen, who will conclude with the final talk relating to development plan challenges. Stephen.
Hello everyone, I hope you can hear me clearly. Thank you, Matthew and Sasha. Hi everyone, good afternoon, nearly just anyway. It's nice to have so many of you listening and watching. So we now turn to development plan challenges, and quite where the development plan system will end up when Mr. Gove has had his chance to fully consider it, no one knows, but as Jenny mentioned, we have the statutory primacy of development plans, so they remain at the heart of the planning system, applying section 38(6) of the 2004 Act and section 70 of the 1990 Act. Hence the importance of the nature and scope of any right to review the lawfulness of such plans and the court decisions on these. So we have from the last 12 months decisions relating to both section 113 local plan challenges and section 61N challenges to neighbourhood plans. And we have two on the local plans, which relate to firstly the strategic environmental assessment and alternative sites, and secondly the alteration of the greenbelt to meet housing need. And with regard to the neighbourhood plans, again we have two challenges to highlight, one on the time limit for challenges to a neighbourhood development plan, and secondly on local green space allocation in a development plan. And last year there was the Lochalork case, which Jenny referred to again, but this is a new decision which I'll highlight shortly. So turning first to the local plans and the Flaxby Park case, this was a competing sites case, and the requirements under the SEA Directive Article 5.1 and the regulation SEA Regulations 2004, that's Regulation 12 under that. And in essence, Harrogate had originally identified one of two options, and one was the claimant site, and they were found to be finely balanced, and indeed the consultants advising Harrogate concluded that based on broad locations of the sites, they were very similar. However, the chosen site by the council had direct access to the rail corridor through two operational stations and proximity to existing settlements and services. And it also had the ability, because it's a broad location, for flexibility. And before addressing the three grounds of challenge to the plan, which included the council's selected new settlement, Mr. Justice Holgate set out the relevant principles, which I summarise on the slide, and highlighted that the reasons for a decision in a local plan need only be succinct, referring to the principles set down in the Waverley Borough Council CPRE Waverley Borough Council case. He also referred to the principles for a public law challenge regarding reasonable alternatives, and again, you know, the wide discretion that decision makers have with regard to those. And we'll see how that works in practice, because it was held with regard to dealing with the grounds in the order the judge dealt with them. And there were the three grounds, as I said. It was held there was no merit in the contention under ground two that there had been a failure to compare the broad locations of Flaxby and Greenhammerton, Catal on an equal basis to those which had been done for the selected site. And the complaint really was they hadn't had regard to the broad location for the claimant's land, but that was, they brought up this wider area late in the day with no explanation for the delay, and it was held by the judge that didn't undermine the council's assessment. And with regard to ground three, it was claimed that there hadn't been a proper assessment of the viability of the new settlement. I'm sure those of you who've been involved in these plans have heard that before. But again, important to highlight practitioners, matters of viability are not open, it was held, to challenge in the court unless shown to be irrational, because there's an enhanced margin of appreciation for such a technical matter. So even wider than the normal judgment matters. There was one ground in which, and that was ground one, there was partial success for the claimant, and that was in relation to important matter, who made the decision on the final plan and the SEA assessment, and it hadn't actually gone to the full council, which is required under the local authorities functions and responsibilities regulations, and those involved in this should check, you do comply with that. And there's important discussion, which I commend to you in the judgment, about the appropriate remedy, whether the whole plan had to be remitted for consideration by the council. I mean, it was in fact remitted, and shortly after that, the judge made the order, the plan was actually adopted on the 9th of December, forgive me, the judgment having been late in November. And therefore, as I say, it was a Pyrrhic victory ultimately, but there was just that short point worthy of note. And the other matter worthy of note is the important discussion about the limited role of witness statements in such cases, and judge making the point, much of the factual matters can be dealt with in the statement of facts and grounds. So turning to the second local plan case to be considered, that's the Cherwell Development Plan Watch, and this tells you what the duty to cooperate can mean in practice, and that is an example, which I certainly come across, of the deep felt resentment residents of one area often feel when their authority acting under that duty to cooperate decides to accommodate the housing need of a neighbouring authority. In this case, Cherwell, in essence, accommodated the additional 4,400 homes to assist Oxford City Council, Oxford City meeting its need, and Cherwell did that by releasing land from the greenbelt and finding a replacement golf course for development. The Cherwell local plan inspector found the exceptional circumstances to alter the greenbelt boundary, now in accordance with 140 of the NPPF. This was challenged by the claimant, the local residents associations, and the adoption of the planning inspector's recommendations by the council was at the root of the challenge. Worthy of note, there was of course the two parallel processes, because the Oxford local plan was proceeding, and at a preliminary hearing of that, the soundness of Oxford's approach was considered with the claimant, the district council and Oxford City Council all taking part. And this was something that the judge noted later on. Just looking briefly at the grounds, the ground one contended that the inspector had failed to take into account the reduction in housing need, because there had been a noted reduction as a result of the 2018 update of the 2014 assessment. The case of Waverley, the CPRE and Waverley case, had held it was not wrong in principle, let alone unlawful, for a local planning authority to incorporate a proportion of unmet need from a neighbouring authority. And it was also pointed out by the judge, and worth bearing in mind, very much worth bearing in mind, that the assessment of housing need is not wrong in principle. The assessment of housing need is not an exact science. It's a classic process of evaluation. It's inherently imprecise, and there's no prescribed uniform approach, and again illustrates the broad scope for a lawful planning judgment that is available in such circumstances. Thus, it's worth just noting this. The court will consider the extent to which the claimant has participated in the housing need debate overall and in the neighbouring authority, and all the parties were fully involved and aware of the Oxford local plan process. The Cherwell local plan inspector recognise those conclusions of the recent examinations in both West Oxfordshire and the Vale of Whitehorse on the same basis. And it's important to note it's not for the local plan inspector, the Cherwell local plan inspector, to have to assess the need in both areas. That inspector was entitled to rely upon the Oxford judgment and could not be criticised for that, so the court held. And it's worth remembering the Keep Bourne End cases, Bourne End Green case and the Airborough Neighbourhood Development Plan Forum case, dealing with similar matters, which I referred to last year in these talks. So the first ground of challenge was rejected by the judge. The second ground was regarding the replacement of land for the golf course, and the court, in simple terms, just found that the inspector and therefore the local authority came to a decision they were entitled to come to. So those were the local plan cases I just wanted to quickly highlight for you, worth looking into, cover matters of relevance to you. Can I turn then to the two neighbourhood plan cases? And the first one is the filed Coast Farms, which went to the Supreme Court. And this is important, not just because of the specific point it dealt with in terms of the time limit for challenges to an NDP, which is a terribly important point for practitioners, but also a strong reiteration of the deference that's shown both by the legislation and the courts to neighbourhood development plans. And you will see from this slide, there is a strict approach to judicial reviews of neighbourhood plans, and they're based on the three different events on the plan, unlike under section 113 of the local plan. They're based on the making of the plan. You have to challenge within 6 weeks of a decision with regard to that. Making is equivalent to adoption. Consideration of the examiner's report, though, note, there's a separate challenge for that, again within 6 weeks. And finally, in relation to the holding of a referendum. So in this case, in essence, the challenge was within the 6 weeks of the making of the plan, but not within the 6 weeks of the decision of the local planning authority, who didn't accept an amendment to the draft plan recommended by the examiner. This is the St Anne's on Sea near Blackpool neighbourhood plan. And this was in the context of an absence of a 5-year housing land supply, not an uncommon context in this respect. And the amendment would have resulted in the claimant's land being included with the settlement boundary. However, as I say, the planning authority rejected that recommendation because of the potential impact on the Ribble and Alt estuaries, SPA and Ramsar site, and they considered it didn't meet the basic conditions or the EU obligations. As I say, C filed its claim, but not within the 6 weeks of the decision of the authority to reject the inspector's recommendation. Thus, the planning authority objected that the claim was filed out of time under section 61 subsection 2, should have been within the 6 weeks of that decision. And the claimant replied and relied upon 61N1, the first one. That's they say, well, okay, but you can still challenge within 6 weeks of the making of the plan. Both the planning court and the Court of Appeal agreed with the planning authority. The Supreme Court, when it came before them, referred to the long-standing tension between whether an early challenge was required or a party could wait until the end of the process, and commented that it's sometimes Parliament make it clear, providing that a challenge may be brought at the end of the decision-making process, or that in the sense of section 113 means that the majority of challenges to a local plan must be brought after the final version is adopted. And some of you may be aware of the Many Down case. The Supreme Court held that case law indicates there is no clear or obvious resolution of that tension, ultimately a choice has to be made between competing interests of different kinds. But Section 61N makes different provisions to address the issue in relation to the making of a neighbourhood development plan. Here's an important matter to grasp. They held that Parliament was entitled to strike the balance in this particular context in the way it thought fit. And the words of the provision itself provided a clear answer as to how it intended that it should be achieved. And although the preponderance of judicial authority tended to favour the weight to the end approach, as in, some of you will be familiar with the Burkitt and Hammersmith and Fulham litigation, but the links and similarities of the process for local plans and neighbourhood development plans are not so great, such that you render a challenge early principle for neighbourhood plans incapable of being rationally applied. And again, very important to note, they talked about neighbourhood plans as the product of separate legislation, which of course is absolutely right, with the promotion of local democracy primarily in mind, and critically involve the holding of a referendum. It shows the importance again of neighbourhood plans as attributed to by the courts. And they therefore held it's understandable that Parliament should have decided to avoid the too frequent overturning of referendum results by public law challenges made after the event, based upon allegedly unlawful acts and omissions occurring at an earlier stage in the process. And they held that Section 61 was entirely restrictive, that was restricting existing rights of public law judicial review and not permissive, and therefore, the 6-week periods restricted it clearly and applied, because it didn't create new general public law rights. And that's the words where they say the challenge has to be within 6 weeks, only if in each subsection. So that important case, as I say, for practitioners, do beware of the time limits that apply, but also do beware of how difficult it often is to challenge neighbourhood plans, given the importance attributed to them of being a local, in the true sense, local in terms of community plan. And then just finally, just a few words on the second neighbourhood plan case. This was a challenge under, again, Section 61 N2, subsection 2, on the council's decision to accept the recommendations, in this case, to accept the recommendations of the examiner in relation to the Wychford neighbourhood plan, that's near Ely in Cambridgeshire. And there were, in this case, two relevant strategic policies in the East Cambridge Local Plan 2015, dealing with the levels of housing, growth 1, and the locational strategy for that housing, growth 2. The local plan was proposed in the spring of 2016 to be replaced, and the hearing sessions for the emerging plan were held between June and September 2018. The inspector recommended main modifications, including the deletion of the site owned by the claimant as a local green space designation. And following further correspondence from the inspector, the district council resolved actually to withdraw the plan as a whole because of concerns over the fundamental nature of the main modifications, and not just the LGS designation of the claimant's land, but other wider matters. But the inspector refused the request of the claimant's planning consultant to explain the basis of a recommendation, saying that she was unable to provide this as she had no jurisdiction, given that the council had withdrawn the plan before she wrote her report. However, at the same time, the neighbourhood plan came forward, and that, in short, included the site as local green space. The claimant objected to that designation in the neighbourhood plan on the basis of the local plan inspector's recommendation to not designate the site, and disputed the adequacy also of the housing supply in the neighbourhood plan, again, a common and recurrent theme. The claimant also proposed part of its site could be used as local green space and part for housing to enable that. And they also relied upon the Lochalort case that Jenny referred to earlier. However, the neighbourhood plan examiner concluded the strategic policies did not require Whitchford to accommodate more than small scale development within the development limits. The two grounds of challenge were rejected. The judge firstly pointed out the differences between local plans and neighbourhood plans and the lesser requirements for neighbourhood plans. And with regard to ground one, basically rejected it on the basis that as a whole, looking at it, the examiner had properly considered the criteria for local green space designation. And it wasn't for the examiner or the council to make further inquiry as to why the local plan inspector recommended deletion of the designation. And under ground two, regard to the improper interpretation of growth two, essentially it was argued that because it was the inspector found that growth one was out of date, it followed you had to, in other words, a level of housing, you had to investigate locations. But that was rejected, saying, well, you know, this village, this settlement was only identified for small scale development. So I'm afraid the claimant was unsuccessful there. So thank you for listening. There are my lists of case references. Anyone who's interested, some of the cases I referred to in passing, they're there. And I will now hand back to Neil.
Thank you very much, Stephen, and to the other speakers. Now is the time for our panel discussion, and we have got just under 15 minutes, so well done to the speakers on timing as well. Can I just start on one that arises from the heritage talk? Matthew, you referred to the Bedford case and sought to, well, you indicated that some doubt can be cast on it. So my question is, can practitioners still rely on Bedford when assessing A, the threshold between less than substantial harm and substantial harm, and B, when seeking to articulate the degree of harm under the category of less than substantial?
Thank you, Neil. I mean, I think the first point is that Bedford has always been extended perhaps somewhere beyond the facts of the case in which it was just, you know, the particular circumstance in which it was decided. I mean, I think that Bramms Hill provides a very clear indication that an overly prescriptive approach to the meaning of substantial harm or less than substantial harm is inappropriate. So I think if you look at Bramms Hill, the particular paragraphs I think I referred to in my talk, I think it's paragraph 74 of Bramms Hill, I think that provides a clear reason why decision makers shouldn't treat themselves as constrained by the obiter dicta in Bedford.
Thank you. So can we still rely on it?
I'd say no.
Because what the judge was doing in Bedford was to interpret the words in the NPPF, it seems to me that one can still place reliance on it, but it has to be a matter of judgment in each case, whether harm is substantial, less than substantial, and if it's less than substantial, where it comes on the scale. And now a question probably for Sasha. Sasha, you refer to the Kinsey case, and in that case, Mrs. Justice Lang referred to the need to articulate the degree of less than substantial harm. I think it's paragraph 88. If a decision maker does not articulate the degree of less than substantial harm, do they, now that we've got that advice in the PPG, do they err?
Potentially. I think it's much safer to articulate where it sits on the scale, because also you then make more credible a defence against a irrationality challenge on the basis of coming to the view that the public benefits outweigh the less than substantial harm. I think the greater clarity you can set out the balance between the two factors, the more likelihood is that the decision will be defensible in my judgment.
Thank you. And that takes us on to the question from Malcolm Hockaday, which is, why is great status given to conservation officer advice, a mid-level position in a planning department, when the balancing of harms and planning benefits are written up as the advice of the chief officer? Is there any process difference from other internal advice, e.g. a tree officer? Who would like to deal with that? Shall I have a start on that? I don't think that any particular status is given to the conservation officer advice, other than it relates to a matter which local authorities must have regard to pursuant to a statutory duty. So it's rather different to a policy requirement. It is a statutory duty. And Sasha will tell me if I'm wrong, because he was involved in the Kinsey case. But I think in Kinsey, the point was that particular advice had not even been reported to members. And that would apply equally to advice from other officers. On the second part, the balance, I think the balance is for the planning officer, and I agree with that. The conservation officer will advise on whether there's harm, the degree of harm, and so on, and then the planning officer has to carry out the balance.
I agree completely with that. They may take a different view, give different weight to matters, the planning officer, I mean, in the overall balance than the expert officer, but that's perfectly lawful as long as you say, Neil, they do so in accordance with any statutory or policy requirements.
Thank you, Stephen. Now one for you. There's a question from Henry Peterson. Are there any judgments or cases other than the two at Dawes Hill which have dealt with decisions by local planning authorities to vary or exclude sites from the boundary of a neighbourhood area as applied for? And perhaps we could extend that and just consider not just whether there are any cases, but what's the approach to be taken. Are you happy to deal with that, Stephen? It's addressed specifically to you.
Yeah, I mean, I'm not aware of any cases. I do have in the back of my mind, no reported cases, I should say. I do have back at the back of my mind at least one example of where it's happened post Dawes Hill, but I don't think that ever went to court. And it very much, I mean, in terms of the approach, very much depends upon the circumstances. And what you can't do is undermine. I mean, the key thing is you can't undermine the allocation of a strategic site, for example, a la Dawes Hill, in the local plan. Strategic policies are very much, of course, still under the guidance and under the legislative framework that applies for the local plan rather than the neighbourhood plan, albeit neighbourhood plans do have, as it seems to me, ever widening powers and implications.
Thank you. Anybody else want to add anything on that? We have got another question on neighbourhood plans, but I was going to, just so that we don't get too tied down on neighbourhood plans, we can come back to that. Can I just raise something which we all have to deal with from day to day, the approach to the National Planning Policy Framework and Para 11, and the way that the courts have dealt with this. And I'm thinking particularly the Peel case. I mean, you look at a plan, it has a plan period. We've got past the plan period. Why isn't the plan then out of date? I mean, a member of the public looking at it would say it runs to 2020 and it's now 2021. Why isn't it out of date? Apart from the fact that it may give the wrong answer if it is. Matthew.
Thanks, Neil. I mean, I think the first point that arises from the way it was dealt with by the Court of Appeal in Peel is that the framework uses different language. It doesn't refer to time expiry, it refers to being out of date. And the approach of the court was to say that there's nothing in the framework to suggest an automatic deeming out of date upon expiry of the plan period. The point made by the Secretary of State was that many policies in the plan will be devised without reference to the plan period and will clearly be intended to have a longer application. And obvious examples would be things like greenbelt policies or countryside protection policies. The Court of Appeal confirmed that the key questions are going to be whether or not those policies have been overtaken, either on the ground or by national policy, change to national policy, or by other events. But time expiry of the plan itself, it's not a sufficient consideration.
Anybody who'd like to add to that? I mean, it's pretty clear. I think that there's a difference, as you say, between time expiry and out of date. Has it been superseded by other events, whether it's policy or anything? And the deeming out of date when you've got an insufficient housing land supply is a specific provision in the footnote. And also that seems to me to make sense, because the purpose of the plan, or one of the purposes of the plan, was to meet objectively assessed need. And if it's not doing that effectively, then it's appropriate to deem it out of date until it's put right. It's a kind of safety valve, really. Shall we go back to the question on the neighbourhood plans that we've got? And this is from one of the attendees. Challenges to neighbourhood plans soon after the 2011 Act often sought injunctions to prevent the referendum being held until the challenge was resolved, and they were invariably unsuccessful. And does the Supreme Court case, which you mentioned, Stephen, mean that such injunction requests are more likely to be successful or not? Sorry, Stephen, thank you.
Sorry, Neil. I don't think you do need an injunction, because as long as your challenge to the earlier stages is in time, then your challenge remains. I mean, there might be tactical reasons, and I think in those earlier cases, one or two that I've advised in, I think, were for tactical reasons as to whether you need an injunction. And as the questioner says, and they weren't generally successful. But the important thing is the Supreme Court, one of the basis of its judgment was that they wanted to avoid unnecessary challenges to referendum and cast doubt over referenda. But oddly enough, in the last case I referred to, the second of the neighbourhood plan cases, the Abbey case, although that was a decision before the referendum, the authority there went on in that case to have the referendum. The referendum was held and the plan was upheld, but it made no difference, I don't think, to the actual litigation. They just chose to do that, and no one, as far as I'm aware, I mean, they may have done, but certainly no injunction was granted in that case, preventing a referendum being carried out. So I don't think, unless I'm missing something, I don't think it affects the merits of your individual challenge.
I agree with that, and I don't think it makes it any more or less likely you'll get an injunction. You probably won't get one, but depends on the facts. And I think the point of the Supreme Court case on timing is the words of the statute. They're different, and it's, I think, is probably as simple as that.
I agree.
Let's just go back if we can. I think we've got time for one last point. Chris Davies has asked, similarly to the Kinsey case, when the development control case officer has sought specific advice from the Planning Authority's development strategy team in relation to policy clarification, should these comments be specifically highlighted as coming from development strategy, as you would for other technical bodies, or amalgamated into the overall assessment of the local planning authority? My initial reaction is, I think as long as that matter is put before the decision makers and before the committee, that's sufficient. You wouldn't have to specifically identify who they come from, but I don't know whether others have a particular view.
I'd take a slightly different view. Just
Good.
because it seems that unlike Kinsey, the judge was very concerned about weight and the weight to be given to a specific consultee. And I think by identification, it's then easier to persuade a court that the members have had a sense of the weight to give when they can attribute it to a particular part of the council. That would just be my sense.
I think it would certainly be advantageous to identify who it came from, but I think that if you didn't, there would be a reasonable argument that, so particularly on a matter of policy and what does the policy mean, which is essentially a question of law and reading the words of the policy, the local authority would probably be safe. But I agree with you that the safest course of action is to identify the person who gave the comment.
And it does seem that claimants are specifically making criticism of officers' report that do not expressly identify where the comment originated from.
Yeah.
And also I have had a case go against me where an officer's report has not identified a response from a particular consultee at all, just left it out. And of course it depends how important that is, but that can be another problem. But I think we've probably come to the end of our time, so thank you very much indeed to all our speakers, particularly to Jenny for recording her contribution. Some people in those kind of circumstances say terribly sorry I can't do it, but many thanks to Jenny for doing it, although she was unable to be here. And thank you also to Sasha and Matthew for their talk on heritage issues, which really brings to the fore how important those points are, and to Stephen for his detailed knowledge of local plans and neighbourhood plans. And thank you for all of you who've attended. And so that's goodbye from us.